amount because it, according to them, misappropriated a couple of their cultural icons, their traditionally cultural expressions. And then Disney registered Lilo and Stitch, and Hawaii has been in a lawsuit ever since. Hawaii tried to address the issue, and they've taken suits against all kinds of people in trying to address it. They had a convention in 2003 with their cultural elders, as it were, or statespeople. And they had a declaration which was adopted by their state legislature. Unfortunately, it has not provided them with any kind of protection. In fact, a non-Hawaiian artist, photographer, used it to sue a traditional artist or indigenous artist over a hula photograph that he had taken, the pose of the hula dancer with her arm back. The local artist had tried to create that into a stained glass piece. And Reese, who's very popular with all them, he sued, and he won in the Hawaii courts. So this is a big issue. And Monica brought this issue to my attention last year when she was meeting with artisans from around the area. And we were trying to address it. As you all know, we're going to be hosting the FestPAC, the Festival of Pacific Arts, here in Guam in 2016. All the various indigenous artisans and practitioners are very, very concerned about the misappropriation of our traditional cultural expressions, whether it's our omelet, whether it's our dance, whether it's our song, our icons, all kinds of things. And so the speaker felt that it was imperative that we do something to try to see if there's a way that we can address this. We're going to have to do quite a bit of research amongst individually, because this is not something that can be addressed by one person. I mean, everybody owns a computer. So I expect everybody to go on their computers and do some computer searches to try to figure out how we can address this, because the Hawaii one wasn't able to provide them the protections that they had. Probably the best ones that they have right now are the Native American ones. But the problem with the Hawaii statute was Hawaii could not be afforded the same protections because they're not a recognized Native American tribe. Akaka tried to get the legislation through to create that. He was not successful. And so I know there are some people on Guam who believe that we can, under Title 25, just declare ourselves to be a Native American tribe. I kept trying to use the example of Hawaii not even being able to do that themselves. So I'm looking to all of you to help our artisans and our traditional cultural expressions protect against the misappropriation and the misuse of what's traditionally our expression, whether it's the petroglyph men or Gadao or whoever, whatever, stories coming out as cartoon characters or coming out in the next James Cameron movie or something. So I don't know. I wish I had the answers, and I'm embarrassed to admit that I did not introduce the legislation because I didn't think that I had the answers, and I didn't know how I was going to be able to address it. And it was a speaker that thought, well, maybe if we get a group of people together with some brains and some know-how, that we would be able to come up with a way to be able to address this. This is not something that, not the Hawaiians were not the only ones that tried it. Alaska has legislation specific to themselves, but that only applies to those within the tribe, within the state. And it's just, and I heard the discussion of Gumat this morning on the radio about whether or not it includes those that are living away. And the Alaska one shows that they're only protecting the ones that are within the state and within the tribe. Then there's a whole problem with even the SPC one. The SPC one is such that it has to be, it really is tailored to really small islands where they can show that it belongs to a certain tribe, a certain clan, or a certain indigenous group. And so it makes it really difficult. So I don't know how many of you have done any reading prior to this meeting, but what I can do is I can, as a starting point, email all of you copies of a couple of articles that I've been reading to show the depth of the problem. And I'm hoping that everybody will take it from there and do their own branch out. I mean, because this really would be full-time almost. To the various articles, to look at the Panama example, to take the SPC one, and try to figure out if there's a way that we can fashion something for Guam, because it's imperative that we do something. I mean, I understand when John Lawrence brought this to me almost 10 years ago, the need to try to protect it, and especially now that we have the games coming, and with all of our artisans and all of our cultural practitioners bringing forth their knowledge, how can we protect that? And so if I'll send out the articles to everybody electronically, and hopefully after you've had a chance to read it and do some research, we can get back together about some ideas that you may have. But it isn't an easy nut to crack, but it is something that really needs to be addressed, because we don't want. And I know that the artisans, I didn't realize it until I spoke to some of the dancers, that, I mean, they were really concerned about making sure that nobody else copied certain things that they did. Yeah, and so it's it really is and I just brought this out to try to even figure something like this, whether is this a traditional cultural expression, or is this an artistic expression that this artisan, corned beef, can trademark for himself, but can we trace it back culturally? Can we trace it back culturally as a talking stick? Was it used culturally in the Chamorro culture, or was it not? And in some Pacific cultures, a talking stick is, but I don't know if we had that much order. But it's a beautiful piece of art. And so, anybody have? I know Monica's been working hard with the the group that comes in, CPAC. If you can speak to those issues about what those discussions are, and I know after your meeting 2 years ago, they were asking about making sure that there's some kind of trademark protections. If you can just address that, just so everybody else here has an understanding of what the issues are.
Thank you, Vice Speaker. The South Pacific Commission, or the Council of Pacific Arts and Culture, oversees the Festival of Pacific Arts, and one of their priorities is to ensure the protection of all of the artists and practitioners that participate in the festival. And they have draft legislation that they've distributed to all the countries, and they themselves are finding difficulty in ensuring that all of the member nations adopt this policy. One of the at a minimum, what they're hoping is during the festival we will be able to ensure that the intellectual property rights of all of the practitioners are protected, just by virtue of not allowing cameras and, lots of signage that this is intellectual property. But the long-term goal is for each jurisdiction to adopt a policy in their country or island nation. Yes, it's going to be really difficult for us here on Guam, and also Hawaii being the next venue for the festival. I mean, those issues will be addressed again with Hawaii. So I know that at the recent council meeting in May, there was a discussion on how Guam has progressed. And so we did report then that there was legislation to establish the Guam Trademark Commission, and that as soon as the first meeting is convened, we will apprise them of all the developments. But they're standing ready to assist us in any way that they can.
What has been their experience with the legislation that they adopted? I mean, it had to be almost 10 years ago, because when John Lawrence was president, that was at least 10 years ago.
I think there have been a few countries that actually have adopted it at the national level. I believe Vanuatu was one of them. Fiji was also another country that adopted it. I'll have to verify if there have been any other countries, member nations of SPC, that have adopted the policy. But a lot of the nations are also themselves having difficulty. Solomon Islands themselves, prior to the festival in 2012, did introduce the legislation, but I'm not sure if it eventually passed before or immediately after the festival.
What kind of problems have they talked about that they've had with the misappropriation of or misuse of their traditional cultural expressions?
I think it's just the general problem of outsiders coming in. In Fiji, they had an issue with a large garment manufacturer using some of the traditional Fijian patterns. I think you recall that was a couple years ago, and so that kind of stuff where outsiders, especially large manufacturers, will come in and take these traditional styles and incorporate it into their mass market distribution channels. So things like that, where they'll take the patterns, music also, but it's different for each jurisdiction.
They adopted the legislation, right?
I believe so, yes.
Has that legislation provided them any protection at all?
I'd have to go back and check. I know that when they caught it, they did um, contact the manufacturer, and there was some communication between them, and then there was then there was a public apology, and then some kind of compensation in the Fiji incident. But
Go ahead, Joseph. Did you have a comment? Go ahead. Anyone?
The International Council of Museums, that represents over 2,000 museums worldwide, had chartered another association in the Pacific Rim, which is called the Pacific Island Museum Association, for which I chair now for 57 museums throughout the Pacific. One of the things that we have noticed from Australia, New Zealand, all the way down to all the other islands, is that in the field of museology, which dictates authentication and all those things that matter to that culture, what is placed in each museum that is central, or shall I say paramount to that culture, has been a bone of contention, because the expression, as you stated, the expression of art, a good example would be the staff you hold on to, could be the expression of the artist, and it may not, or it may have an authentic lineage, if I may call it. And so these several thousands of museums, and most especially under the Pacific Island Museums Association, they are impacted to the extent that there's a great amount of discussion amongst museum directors, curators, as to what is appropriate when you place your story, either by way of artifacts or expressions of art and even music, if whether or not there's something that weaves or links that culture truly. And that has caused a lot of a division in some cases, because you've got the younger who want to express themselves, and they may not have a direct connection to the authentication process. Nonetheless, it's an expression of their modern day experience of their culture. So the museums as well are looking at this issue, and each museum has come up with some concerns that deal specifically to placing and authenticating what it is that they place into their museum. So that's why in the 2016 venue, there'll be folks bringing in for the museum items of it, or expressions of their culture. So those will be displayed at the traveling exhibit area of the new museum. So I just bring this to the table, that the core of this issue does not only hit the commercialization and the money-making portion that shows expression by sales. It also hits the very core of authenticating and truly embracing the culture through authentication. Or in our expression for Chamorros, for example, we have so many Chamorros who were from Guam but have since moved away. And there's a cultural resurgence to identifying as a Chamorro, even if you weren't born here, but your parents were, and you're living in Seattle, or you're living in California or Oregon or in Virginia. There is an expression that wants to come out. And we're noticing this with the 2016 Festival of Pacific Arts grouping. There's a great interest of our off-island Chamorros who wish to participate, and a good example would be dance. In order to participate in our venue, is there a authentication that places it to Guam versus the diaspora of how it's expressed elsewhere? So museums are challenged today, and one of them is on intellectual property rights. It's very concerning. A good example would be a very good example would be folks will come out, and we already are seeing this here in Guam. As soon as folks realize that there's the realization of a museum being built, I'm getting phone calls from folks that says, my great-grandmother had this and it passed down to me. Or I have this and I think it would be of value to the museum. So the museums are caught in a situation as to whether or not those pieces will make their way contemporarily or culturally.
Just so the listening audience also is aware, one of the problems that the Hawaiians had was the fact that some of the stuff that, well, Lilo and Stitch, and even there was even the whole controversy with Dodge having the big kahuna, and all three of those are really important characters or names within their culture. You know, the kahuna being a chief. I mean, how would we feel if Kia decided it was going to do a magatlahi, and how it was portrayed, or even worse, to have someone come out with a cartoon like Lilo and Stitch and take our Suruhanu or Suruhana and bastardize it into a witch doctor. You know, we hold these men and women with great esteem within our own culture, but to others it can be, you know, a source of that they can make fun of, or they can poke fun at, and it's those kinds of things that we're trying to protect in the traditional cultural expressions, to make sure that people don't use things that are important to us in inappropriate ways. The Indians have brought the lawsuit against the Redskins. It's still going, you know, the character with the feather, and though they won in court, it's still being fought. And so it's those kinds of degradation or putting in a bad light important things to us. I think the misappropriation to some may not be as bad as, you know, desecrating something that's important to us. I don't know whether commercial is more important than the desecration. There are some that would feel that desecrating certain of our icons would be worse than stealing an idea and making it into a beautiful piece of art. They wouldn't object to that, but making fun of someone that we hold in great esteem would be. Anybody else?
Vice Speaker, what I can do is, if I could get the distribution list of everyone, I can go ahead and email to everyone all the work that the SBC has done so far, and see, and then everyone can review that also. But they have done lots of work. They've worked in conjunction with WIPO, the World Intellectual Property Organization, and they're also work in collaboration, the two organizations. So there's lots of documentation on what they've done, and I'll be happy to pull that down and send it off to everyone also, because it is very extensive material.
If I can make sure everybody signs in and leaves an email address, what I'll do is what I have, I'll send out electronically. What you have, if you would send it out electronically, and have everybody. Did you want to say something?
No, yeah, just real quick. I'm sorry. Two quick things. Number one, I think the objective here is to, and correct me if I'm wrong, is to just sort of expand upon the existing U.S. trademark law and adopt whatever protection rights that allows. And then have it specific to our cultural icons and everything that you mentioned. Number one, and just to maybe have a local layer of protection. Is that correct?
Yeah, sort of like an attempt to try to looking at the Hawaii model, looking at the Alaska model, looking at the Native American model, and trying to figure out how, because there is the overarching federal
U.S. trademark law,
and patent law, which none of us can, go against. but it's just trying to figure out some way that we provide even more protections for ourselves and our cultural expressions.
Okay.
And so that's trying to figure out how that's done is what I'm hoping that we can do.
Okay.
And so if everybody has their email addresses, we can, and Monica shares her stuff from WIPO and the South Pacific Commission, even their legislation, that might help, but that we have to figure out something. I just don't know how.
But I mean, at least on the commercial goods side, that's covered under the Guam product seal portion, correct? For commercial use of actual products. And
correct. And this is something that we deal with in working on the rules and regulations for the Guam product seal program. The difficulty that we've had is quantifying or giving value to intellectual property. So this, if we set the parameters as to what is traditional cultural expressions, at least this gives us an idea. We can qualify and authenticate, and at least that would at least say this is officially recognized as cultural products.
Yeah, I think there's two things. One, whether or not it was actually made here, but then whether or not it takes a traditional cultural expression.
right.
Whether it's one of our omelets being taken by Johnson & Johnson that, how do we protect that? That to me is one that I was wondering about.
Yeah, and it makes sense.
That kind of thing. I think it makes two different things. I mean, the fact that somebody wants to make this and you can put a made on Guam seal on this. Yes, it was made on Guam by an artisan on Guam, but is it a traditional cultural expression that can and should be trademarked separately as a traditional cultural expression, or as a patent that the artist can patent for himself?
Right, and it would have to meet a certain criteria, presumably, according to the standards that we will establish. But at least it would give some guidelines as to what qualifies traditional Chamorro expressions. So you wouldn't be able to say cultural, this is a traditional cultural item unless it actually falls within those guidelines.
Ken, I think you guys have the authentication book already that you guys put together a long time ago, right? So that can be a start, but the thing is that this is really amorphous. I'm not sure how to put my arms around it, and I thought, okay, speaker, thanks.
From the business development standpoint, we're not looking at restricting mass production, right? Because I'm thinking about the Fiji. Was the issue the misrepresentation of the cultural item, or was it the mass production of those Fijian clothes?
That was both.
Yeah, I think one of the issues is going to be on some of the traditional cultural expressions. If we can claim and show the petrolith men are, those characters are traditional cultural expression of Chamorros. If, who's the big, they decide they're going to do a whole series of shirts with it. Yeah, like, I got, and how they do it is important. And so those kinds of things are, whether, I know that there's a number of artists who have paintings, like I have a whole series of, in my office by David Splan, with, I was hoping to use as a tattoo, but I'm too afraid. But they have beautiful expressions, and whether or not those, if those are appropriated into somebody, if some of those are taken and put on a shirt, in the same way that the Fijian ones, but which ones are traditional cultural Chamorro expressions as opposed to artistic expressions from a brilliant artist like David. And can he patent it, or can somebody all of a sudden start a company and put them on cups and everything else? That's a whole another issue. But to be putting it on wherever they put it, and whether or not it would be you want it to start appearing on strange articles of clothing that.
Or maybe with just going back to the reference of Lilo and Stitch, maybe we're looking at, let's not take Chief Kapua's image and put sunglasses on him and just kind of keep the sanctity and integrity of the image.
Mm-hmm. Yeah, I mean it's those kinds of things. Which ones can we produce? Yeah, what we have. I think part of it is just trying to figure out which and what are traditional cultural expressions, and what we would be willing to allow its use for. I think in the discussion this morning on the radio, there was talk about, in its production of some of the icons from Guam, making it into certain other kinds of pieces of jewelry would be something else. That would not be offensive, but if it was used for and not somehow we're not being recognized for Guam, and how those things are used, and being able to say you can use it in certain ways, but in other ways it cannot be used.
Yes. Also, something to think about, and I go back to this whole concept of, are we looking at the field of museology, museums, and how they safeguard telling the story of their people, their culture, and authenticating them. And then going outside on intellectual property rights for cultural expression or for commercialization of how the artist expresses what they view in the abstract, more than likely. A good example would be, I have two sister-in-laws are Japanese. One of them currently works for a tour company. And over the years, I've heard bits and pieces of how the legends of Guam have been expressed differently depending which tour guide brought you there. A good example, and I think it was a movement forward in a very good way, was when we received federal funds to do the 17 historical sites and signages from up at the property of Pugan for Santa Agata, going all the way down to this other side of Chamorro Village. And there were really nice plates, permanent plates with stories just actually written out and explaining where you're at. And so therefore, that allowed now to set the record straight in this area. But I don't believe there are bits and pieces, Vice Speaker, out there of every village as to what their story is. And I think culminating for our visitor industry, and I know I'm moving far away from what we're discussing here, but I think it will, outside of the 2016 Festback, will continue to haunt us. If whether or not everybody in a consensus versus the traditional expression. Because when you do consensus, what you're doing is you're putting a lot of people in one table and they all agree to agree, and that this is going to be henceforth the story. So those are didactic movements that can cause some confusion as we move forward with the implementation of any particular recommendations this commission has.
Well, I think if we use what was done by Chamorro, Department of Chamorro Affairs, the authentication booklet, and I think if we can show that something has gone through that whole process, once it makes it through that process, is there something that we can do to protect the way that it's used? And different from an artistic rendition of, expression of how an artist wants to see that. As long as it doesn't denigrate it, to, like the Redskins logo. It just seems to me, we have to figure out something. I don't know.
I want
I'm
to
lost.
also offer, Vice Speaker, since you've mentioned about the book, I will make available to each member of this commission that book so that you have it on your hands. It's only a 35-second walk from here. If you want to get it today after this meeting, we'll make that available to you, or let us know how we can deliver it to you.
I'm glad you're going to take the microphone, because the question will come up, what kind of music is going to be a difficult one to define, because we have small music and it turns into rap, and that's offensive to some people, but it's loved by others. So how do you define
Well, for me personally, after doing 50 years of this type of work, and I did get some advice early stage of my music recording career 50 years ago. I did copyright all my songs in 1969, and the best copyrights and patents that I always believe is our U.S. trade copyrights, and because they offer great protection, even in the international arena, because every country has their own copyright laws. So for Guam, I believe the highest copyright protection to offer our artists is to register with the U.S. Okay, and I'm trying to understand what we're looking for here. What's our objective? And it looks like we're going into all disciplines, right? And all disciplines have different criteria to meet authentication. So we're looking about traditional or contemporary or modern creativity of traditional expressions, because I can do berimbau fusion with a bass guitar with Carlos Laguna and Patrick Paloma in the back. And what do we call that? That's, traditional fusion with a berimbau, with all that kind of sound. So, yeah, we can protect that. But the best protection is still the U.S. laws. There's nothing else that, because that supersedes anything else that we do here. What we could offer probably is an easier way for our artists to register, help them how to register the U.S. trademark, because that would protect their designs. Okay, and if someone comes in and makes mass production of their designs, like sanahais and stuff like that, and depending on how they're designed, we can in the arena of legal matters, I think we can win that, because it protects the copyright is protected by the U.S. law, and it protects our traditional rights. We registered in Department of Timor Affairs, for example. The artist would register here, takes pictures of all the designs, makes a booklet, and sends it in. Registers in our trademark, Guam local trademark for protection, and then sends it in for a greater protection. We could help them, because it does cost a lot of money for individual artworks to be copyrighted. How I did it in 1969, because I didn't have any money, at least was not able to afford $35 every time I make a new song to copyright. But the way around it was to make a book of songs. Let's say my Mariana album or Tomorrow's album, and I put all the music sheets in that book, and I send it in, and it's copyrighted under, and I got a copyright for that booklet and a group of songs. Okay, and it listed all the name of the songs in it. So I'm protected with that. We can do the same thing with designs with different artists. who have cumulative design work. But our goals would be to protect our creative artists, our traditional artists, and what is authentic. That should be Tomorrow Affairs, or someone has a book or something in each artistic discipline would have to qualify for that. Not just one group of people, but different people in the art field. I mean, in the arts, saying in music, for example, or performing arts or applied arts. They have ex-masters that would say, "Oh yes, this would the authentication is, and the history on this is there." So that's how you, to me, you can put authenticity on. What we should be looking at is creating a symbol of excellence. One particular product, and for our magalahi to present to visiting guests, or to heroes here in Guam that we have, or to people who have contributed a lot, and say, you've reached, the symbol of excellence. Anybody that wears that particular sanahi or particular symbol of excellence, we know as Tomorrow people that he has come a long way or has contributed a lot to the culture. I think there should be a committee that could design that. Thank you.
Last year, the Guam Council of Arts and Humanities held a workshop on copyrights and intellectual properties, and at that workshop we probably had about 40 to 50 artists that attended. I think what we need to do is we need to expand that workshop and then just, educate our practitioners and our local artists of exactly what intellectual property is. It's like a painting by Ron Castro of the Sina. That's his intellectual property. Someone cannot go and take a picture of that and sell postcards without Ron's permission. And same as with Johnny's music. They can't just go and play his music and then sell it, and make money off of it. I think that's what we need to do, is go back to our, one of the things that we need to do is educate again our community on what exactly intellectual property is. I think there's,
since you touched on the music aspect, my understanding in the copyright laws is that once you publicly put out the music, it's a public performance. For example, the Hafide song. Anyone can ask for permission to use and pay royalties on it. Okay, but you have to let me know. Otherwise, you're violating it if you just put out the music and making money out of it. So you have to let know. That's why we always have a list of names there, like the company, the publishing company, and the songwriters, and the recording company has the authority to protect that artist or that song.
And this is going to be a bone of contention as we move forward for 2016. There's going to be a potpourri of commercialization amongst people who want to make money as to how they would engage in commercializing those 2 weeks, Guam. So that's going to be a very big thing that we're going to have to consider as we move forward immediately.
And I think that was the Alaska problem, where they were trying to figure out what is native Alaska art and cultural expression. Yeah. And for certain tribes, the totem pole in a certain way is one thing. Totem poles with strange things on them were not, and trying to protect that traditional cultural expression of a totem pole and not allow it to be denigrated in any way that's completely separate. I agree with you that at some point, and I think Monica was trying to do with the workshops at CAHA, was trying to train the artists to how to be able to copyright or patent whatever they're doing to make sure that they have those protections. I think one of the concerns that the speaker had when she established this commission was more, how do we protect things that are traditionally Chamorro and is authenticated by the authentication process as Chamorro? How are we going to allow people to talk about the Magatlahi or you know, the Matuas or whatever, and what if people take it out of context and somehow use it in an embarrassing way? I mean, we've got that's a whole other level separate from the workshops that you're talking about, and even the assistance that we have to be able to get this copyrighted as a piece. But you know, how do you do the Tatamona? You know, do we try to protect it as someone that we respect, or is it going to be, you know, a cartoon character, or worse, a sci-fi horror thing, when that's not, you know, or at least I don't believe it was intended to be. How do we protect against that kind of, you know, we know your songs, but these other things, how do we protect that? And just in the Hawaii example, when Reese took a picture, just taking a picture maybe of a standing hula dancer would have been one thing, all right? Just a woman in a skirt. There probably was nothing to that. But the Hawaiians were upset because the photograph that he took was of a hula dancer in a very specific kind of stance, which had great significance in their culture. And he claimed that since he took that photograph and he copyrighted it so that nobody could make it into postcards, that pose all of a sudden was his. And when a native artist decided that he was going to do it in stained glass, having that same pose, somehow he claimed that as his copyright of a female hula dancer in that, and the native Hawaiian lost the suit. You know, it's those kinds of things that, you know, and I'm embarrassed to admit I'm not that familiar with what are culturally, you know, things that we have to protect. And so it's those kinds of things. At least for me, those were the issues. The copyright ones, I think, are easy. It's an issue of money, and it's an issue of education. But some of the other things that people were concerned about how if when they come in 2016 and the Suruhanos and the Suruhanas do a whole presentation of their healing, and all of a sudden those things are expropriated. How can we protect against that? Because it's not a copyrightable, maybe, I don't know, copyrightable thing for each one of the Suruhanas. They've all learned that traditionally from the one that taught them, and it's been handed down for hundreds of years that it's this certain plant. So they can't really claim to say that that's their formula or how to, it was something that they learned. But how do that, who has the rights to that? Does this have the right to it or what? I don't know. Yes.
Thank you, Mr. Vice Speaker. And so, in learning a lot just by listening, and I certainly will do my share of studying and reading, it sounds like some of the issues have already been addressed and tackled, certainly raised and some studied across the blue continent, right? But what I also hear you talking about is ethics, standards of behavior. How do we get people to behave and conform and respect and regard? And so it will be interesting to see how we do come up with those steps. How do we ensure that there's integrity, respect, and regard for what our people have and have done, right? And then it's always going to boil down to how everyone takes responsibility for it. And then the whole interpretation, that ethics thing is, again, as Senator Mana said, for some, this type of music is great, and they see everything wonderful about transforming it into another type of music. And so it's how is that done? And I think that's a really big question. It's the whole ethics thing and the whole interpretation of expression, so to speak. So, and in working with artists, which are wonderful people, yeah, so yeah.
It would be difficult to regulate or put any sort of restrictions on how somebody would interpret it. Beauty's AI older. How do you, if somebody looks at a Monet, their interpretation and their impression of that image is relative to the work. So we would just have to be very careful with how we approach it. If we're going to put restrictions, at least identify why those restrictions are in place. Are we trying to avoid people from misrepresenting our culture and our people? Look, we never want to limit anybody from expressing their feelings and thoughts and passion about Guam and our culture. Of course, we don't want that, like you said, to bastardize treating behind all of our traditions and what we grew up with.
And I'm glad you mentioned that because you already expressed two things. One is this the real Monet, or is this a replication of Monet identifying itself as the original? Then the other part would be, how does one express looking at a Monet in modern times? So yeah, those will be things that will impact our consensus building here as to how we want to move forward with the various disciplines in visual arts, performing arts, literary arts, traditional arts, as we relay right now under the subcommittee of Monica and meeting with these folks monthly.
This is it's a huge job in front of us, Vice Speaker, and there's so many parts of it that are going to be very complicated. But I think what it boils down to on this part of the table is you have your traditional cultural expressions, and then you have your traditional knowledge, and so how do we protect our traditional knowledge and our traditional cultural expressions? And one way, and it's just a suggestion, of doing that is actually establishing a national cultural policy and then also do cultural mapping on our island. And so that will assist us in protecting our traditional cultural expressions and traditional knowledge.
That's exactly what I think we were trying to get to, because I think one of the things that they were talking about in the article that I read was that the SPC model was good because if you can show that it belonged to a certain clan or a certain, then there are ways of being able to protect that. But when it's just out there, that's completely different, You know, because I mean, with artists, it's a whole issue. The difference in how they do that between batik and tattoo. I mean, we saw that last night at Tea.
Right.
I mean, this completely different way of being able, and how much of that, what if it was a cultural icon? You know, Sirena may not, we may think Sirena is ours, but it seems Sirena is all the way in Denmark and everybody else.
She's a mermaid.
She gets around.
She swam everywhere, in cold water even. She was a Francus.
Mr. Vice Speaker, you know, I'm sorry I don't have too much time, and I hate to throw like a ice bucket challenge on all of this very, very good dialogue. But just on the business end of things, I understand through the legislation that there was an appropriation through the TAF, and you know, this is something that GVB certainly wraps its arms around in terms of preserving and protecting our culture. I just had some questions. Number one, on the timing of the funding. And I don't know if this would be in this current fiscal year where we add it in, or would it be on this coming fiscal year? I'm not sure if that was a line item in the budget. And then
I think it was last year's.
It was last year, okay. And then the second question is sort of the mechanism. I know the TAF can't write a check to somebody, right? I mean, this has to flow through an entity. And I was just wondering what that was. And then is this commission in charge of how we define spending it? I mean, is it going to be through an awareness campaign? Is it going to be through research? Or is that kind of what we're here to start up the conversation on?
I would hope that it's through here. The contract will probably have to go through them,
Right.
As culture, but what we want that person to do the research on, I think, is something that we have
That we need to
yeah,
define.
we need to define.
Okay.
Okay.
That's all.
No, it's a great question, and we have to do something soon, or we're gonna. It looks like it's going to be $50,000 richer.
Well, thank you, because, you know, the Guam Product Seal program could certainly use it. It could be well spent.
So anyway, I hope everybody left their email addresses, unless anybody else has. I think we'll have enough to read. I read this 10 years ago when it first came out, so I'm going to have to familiarize myself with it, and I'll electronically send out the other articles that I have. Monica will send some she has, and then we'll try to get together in a few weeks, okay? I'll send out a note to everybody trying to figure out what your travel schedules are, or what your business schedules are, and any ideas that you have on the different levels of this, because I mean, this is an onion with multi-layers of issues, and a lot of times we keep trying to figure out it's a piece closest to us, and there's more to it that you see it from a different angle. She's seeing it from a different angle in her, and she's seeing it from a different angle with her trademark commission, and the authentication of whether or not it's made on Guam. Is it Chamorro, or, you know, is macadamia nut a Chamorro candy, for Christ's sake? You know, it's made in Guam. There's a difference between made in Guam and, you know, traditional. So it's all those issues, and can the mark be used for, you know, right now the made on Guam is one thing, but traditional Chamorro art should be a completely different one, or the symbol of excellence is a completely different one of coming from a master, knowing that that's you know. I have a headache. I didn't have breakfast. So anyway, unless anybody has any objection, I'll accept a motion to adjourn. Okay, thank you. Yeah.